Good afternoon and good morning, everyone. My name is Jürgen Kvist. I'm the Director of Industry Practice and Procurement at the Canadian Construction Association, and I'll be your moderator for today's webinar. The Canadian Construction Association represents over 18,000 member firms through a network of 64 local and provincial integrated partner associations. With a cross-country and a cross-sectoral reach, CCA champions industry priorities such as infrastructure investment, workforce development, innovation, and best practices in construction. Our strength lies in our member through the National Advisory Councils representing civil, trade, general contractors, manufacturers, suppliers, and local construction associations. CCA ensures member voices are at the forefront of our advocacy and programming. Today's webinar was initiated by a document created by CCA called Mastering Risk Management in Construction Contracts. The link will be shared in the chat as well. In today's construction landscape, it's increasingly common to encounter non-standard agreements and supplementary conditions. While these customized contracts can address specific product needs, they often shift a greater share of risk onto contractors and their subtrades. Contractors are generally prepared to assume additional risk, provided those risks are within their ability to control and manage. However, when contracts impose risks that fall outside of a contractor's control, they can pose serious challenges, potentially impacting the company at an enterprise level. This document is designed as a practical reference for contractors during the bidding and negotiation phases. It's a goal to help identify, understand, and proactively address contractual risks, ultimately safeguarding against significant financial exposure. Please join me in welcoming our panel of experts today. Nick Willis, Regional Legal Counsel, Western Canadian Buildings at PCL. We have Jessica Sidhu, Product Manager with Kinetic. And we have Bruce Thomas with Ron Eastern Construction Ltd, who is the president. I will hand it over to Bruce, and please enjoy this webinar. Thank you.
Thanks, Jürgen. I guess for the group listening today, we put this package together to follow the flow of the CCDC documents. So we took a look at all the standard documents and the sections, and the way this webinar is organized, and the one tomorrow is following the flow from the very beginning of the contract through articles, definitions, and the general provisions, and then the different sections of the agreement. So trying to make it flow. And as Jürgen says, it's common practice today to see many pages of supplemental conditions amending the standard documents, which the CCA issued to be fair and balanced to both sides, both parties contracting. So we're going to go through each of these sections one by one. We'll do half today and half tomorrow is the intent. I'm going to start right at the beginning. So the first section would be the articles of the agreement, and these are the front end, and I would say the sort of the information about the contract that sets the stage for what's in the contract. And as with all contracts, I think the risk is inaccuracy. The risk is in inconsistent information that may conflict throughout the document. Jürgen, we lost the screen. I'll continue as you get it back. But basically, we're looking to be consistent and accurate in the references to ensure that the information provided in the articles is pertinent to the agreement. Also try to find a balance between overly detailed and too vague. So happy medium with reference to construction management type agreements. One of the articles in CCDC 5B is the cost of work items, and it's pretty critical that the cost of work items are accurate for what would be cost of work, because we'll get to that and how we define the fees for a project. And again, I went through a situation this morning with a client where we were looking at the articles at the beginning, and the way I explained to them is it's the facts. You want to set the stage so that when you start reading the contract, the articles at the beginning will lay out the key elements of the basis for the contract and where you're going. So that's the initial part in terms of it. The next, we can go to the next slide, Jürgen. So again, incorporating now, so the next thing I wanted to touch on was the incorporation of quotations. So again, in contract documents, it's very common that subtrades provide very detailed quotations, and usually they have many pages of qualifications and potentially items that conflict with the contract document we're hoping to sign. I think it's more prudent policy to ask them to extract from those quotations the things that they are important and incorporate them into the contract document itself, as opposed to attaching the quotation as an appendix to the contract, because you run the risk of, if there is a conflict between their quote and what is in the contract, which one's going to govern. So typically our own organization's process is to basically say, no, we're not going to attach the quote, but we will go through it with you and find the items that you think it's important that we amend the terms of our agreement so that it's consistent. This will help with, potentially disputes down the road in terms of clarity. Also, it's important that when you attach documents, contract documents, that you ensure the document clearly says what you can rely on. A lot of documents have reports and testing data from consultants, and to what extent that a bidder can rely on those is important from the perspective of the contract. So again, the focus here is on clarity, it's on consistency, it's on ensuring that both sides understand what it is they're signing a contract for. Moving on to the next item in the articles is compensation, and the various CCDC documents have various models for compensation: fixed price, percentage fee, lump sum fees. It's important, again, that it's clear how that fee is calculated, what it's based on. I think everybody can understand these days the risk associated with escalations. We just came through a very difficult period in COVID where it was really hard to get a grip on exactly what was going on with pricing and how would you articulate it. Typically, a force majeure clause, if written properly, will allow you to manage those risks and point to it. Lately, obviously, the big word is tariffs and how they are handled in a contract. So again, to manage your risk, understand what your rights are with regard to these things. And does the force majeure clause inside the agreement allow for a mechanism for you to make claims if they're appropriate based on what's being provided through from suppliers? From the owner's perspective, we want to make sure that any claim that's considered for that is coming with the appropriate justification and backup, and without it, you can't really process it. The other item on the screen is cash allowances. And again, you want contracts that have some balance. Some items are better as allowances that can be managed with a mechanism, as opposed to shifting the risk to the contractor, particularly if they can't quantify what those costs might be. Moving on to the definitions part. So that was the articles. All the CCDC documents have a list of definitions. It's very common that owners issuing contracts and contractors issuing contracts will amend those definitions, add definitions to them. They fall into various categories. There's a list of them. I think if they're going to be added, they have to be added for a specific reason. The same if they're going to be altered. In Ontario, just speaking from our perspective here, some definitions that typically get added might be around the constructor role in the Occupational Health and Safety Act, to make sure the Act is properly recognized in the agreement and that the role of constructor is recognized and what those health and safety requirements might be. So that those definitions are typically added. And with the prompt payment legislation in Ontario, it's probably important to make sure there's a definition, a recognized definition of proper invoice, even if it's referring to the Act, because it's critical to the payment process. I'd be careful with definitions to make sure whoever's issuing the contract's not getting carried away adding too much to those sections or something that's not appropriate, but they are important. Lately, we've seen trades in particular looking to add definitions of tariffs. In law, duties and tariffs are interchangeable, and typically duties and tariffs are acts of government. So if you look at a force majeure clause and see act of government included, I think your lawyer will probably tell you that you can rely on that pointing towards tariffs and duties, but it never hurts to add the word tariff and or duties into the documents to ensure those are recognized potential force majeure issues. Lastly, on the general provision side of the front end of a document, to me, the biggest risk issue that I believe is important for you is to do your homework on the party you're contracting with. I think we would all say that getting paid is pretty important, and getting paid promptly is hugely important. And I think in most markets in this country, it's not that difficult to do homework on who you're contracting with. getting references on how they pay their bills and how they treat you and what the relationship will be like, because there's not much you can do about a contract, a bad contract in particular, if you sign it with someone that might not even follow the terms of the contract. So doing your homework is a huge risk management exercise, and it's really not that difficult. I would suggest, make sure that if you're signing a contract, it's a good fit for your organization and not a bad fit. Bad fits are only going to end up being bad results at some point. Lastly, on assignments, again, critical to ensure that any kind of an assignment clause that's in a contract is mutual. So that mutual and requires consent. So there's not unilateral and single direction assignments, because you could end up moving from potential good fit partner to a bad fit partner with no say in the flow of the process. So those things that I just went through, from the articles through the definitions, the general provisions, are just sort of heads up, check them, make sure that you're doing your homework at the front end, because if you do a good job with the contract at the front end, then you can just worry about running the construction project and not worry about what's in the agreement.
Thanks, Bruce. So let's move on now to discuss the administration of the contract. And we'll get started by talking about design risk in non-design build contracts. So simply put, contractors should avoid terms that attempt to transfer design risk to contractors in non-design build projects. This is because contractors are not able to effectively manage design-related risk where they are not responsible for the project's design. So this also creates a risk that the contractor will be required to pay the costs of fixing design-related issues as well. So the following are some examples of concepts to look out for. So first, requirements that the work be fit for purpose or fit for intended use. This is inappropriate in bid build contracts because the contractor is not in a position to determine what the designer of the project intended. Responsibility for ensuring that the project meets design intent should remain the responsibility of the designer. Second, terms that impose a duty on contractors to review design documents and warn the owner of errors. These terms can lead to potential insurance coverage issues, and they can also cause contractors to incur additional costs related to reviewing the owner's design. So these obligations, if they exist at all, should be limited to requiring contractors to warn owners about errors that they actually discovered during the course of the work. Contractors should not be held liable for what they should have noticed when they're not responsible for design. Next slide, please. Contractors should also be cautious of accepting responsibility for third-party stakeholder approvals. So, for example, if a contract requires the contractor to obtain a development approval from a local authority, this means that the contractor is essentially at the mercy of that local authority, even if the failure to obtain the approval could cause significant delays to the project. The reason for this is because contractors often have limited or no ability to control the timing or the result of those approval processes. This can create some unfairness to the contractor if such approvals are solely their responsibility under the contract. So to address this, one solution is to split the risk of third-party approvals between owners and contractors. So for example, the contractor could be responsible for preparing the required submission for approval by a set deadline, but entitled to cost and schedule relief if there are any delays after a compliance submission is submitted before it's approved. So it's also important to be aware of instances where the contract gives the owner the ability to exercise discretion. So for example, over the approval of certain submissions. Where it does so, it's important to qualify that that discretion must be exercised reasonably, or at the very least, avoid leaving things to the owner's sole discretion. This is because a failure to exercise owner discretion reasonably could have serious cost or schedule impacts for the project. So for example, imagine that in order to achieve substantial completion, a contract requires the owner to confirm in its sole discretion that the building is fit for intended use. The contractor has a good relationship with the owner's representative, but that individual might leave the project and their replacement may be less reasonable. If the new owner or representative refuses to sign off on substantial completion arbitrarily, it could delay the release of holdback to the contractor and the subtrades. So ultimately, the main point here is that owners should be held to the same reasonable and timely standards as contractors when exercising discretion. While this may seem less important when you have a good relationship with an owner, it's always important to keep in mind that things can change. So the next category we will discuss is the performance of services, execution of the work, and responsibilities section of the contract. And we'll start by talking about standard of care. Contractors should avoid language that imposes a higher standard of care than what is required at common law. That is, the level of skill, diligence, and prudence that a reasonably competent contractor would exercise under similar circumstances. So specifically, contractors should be wary of terms like best in class or highest industry standard. Language like this can cause problems for two reasons. So first, it exposes contractors to uninsurable risk because many professional liability policies exclude liability that arises from a contractually accepted higher than ordinary standard of care. Second, it can expose contractors to uncertain liability because it implies a standard somewhere between industry standard and perfection, and it's not clear where that is. So for example, if the contract requires the contractor to build the project to a best-in-class industry standard, it's possible that the contractor could be held liable even if they have not been found negligent. And worse yet, such losses could not be covered by the contractor's professional liability insurance. So for both of these reasons, it's worth exercising caution when reviewing the standard of care language in your contracts. So our next topic is performance specifications. And simply put, these should be clear and objective. Subjective or ambiguous performance specs create uncertainty for both parties, and they create a risk that contractors will be required to complete additional scope without compensation. If a contract contains an ambiguous performance specifications, this means that the owner and the contractor may come to different interpretations about what is required. This can lead to disputes, and even if the contractor's interpretation is correct at the end of the day, the contractor may have to complete extra work unpaid before the matter is resolved through the dispute resolution process, which can take quite a long time. It's therefore very important for contractors to identify any unclear owner requirements during the contract negotiation process and issue RFIs seeking clarification if necessary. Next topic is means and methods. Typically, contractors are responsible for construction means, methods, techniques, sequences, and procedures, and for coordinating the various parts of the work. However, the industry is starting to see language purporting to make the contractor responsible where the owner dictates means, methods, or sequences of the work. This is problematic because it makes the contractor responsible for items that are outside of its control. For that reason, contractors should consider excluding this type of language altogether, or including appropriate carve-outs to ensure that they are only responsible for their own operational choices and not those that are imposed by the owners. In addition to the above, the following are some risks in this category that are applicable to design, build, and P3 projects specifically. So first, development approvals. So in many contracts, owners are now assigning the contractor responsibility for obtaining development approvals from local authorities. As we discussed a few minutes ago, this is problematic because these approvals can take a long time to obtain and are often subject to the discretion of authorities over which the contractor has no control. So therefore, provided the contractors meet submission requirements, any subsequent delays in receiving approvals should entitle it to cost and schedule relief. Utility upgrades. Responsibility for upgrading the utility side capacity of existing utilities should be an owner responsibility or otherwise clearly excluded from the contractor's scope of work. While on-site utility works can be identified and priced by contractors, the need for behind-the-line utility upgrades is often not possible for the contractor to discern at the proposal stage. And in some cases, contractors are expressly prohibited from contacting utility companies directly. Unachievable compliance criteria, so for example, scheduled service commencement constraints or affordability ceilings, can make it difficult for proponents to submit compliant bids during the RFP phase. This can result in proponents having to incur extensive design development and other upfront bid costs before they are even able to determine whether or not their bid will be compliant. So some potential solutions for this include removal or relaxation of schedule and affordability caps, limited scoring implications for noncompliance rather than disqualification, and increased honorariums, or clarification that honorariums are payable even if schedule and budget constraints are not met. Proceeding at risk. So P3 contracts often give owners the ability to dictate that contractors are proceeding at risk with certain scopes. This can impose an unproductive procedural burden on contractors, but really on all the parties, as they often then require the parties to spend considerable time and effort in determining whether or not the owner was justified in exercising this power. It's therefore important to ensure the circumstances in which the owner can declare a contractor to be proceeding at risk are appropriate. In recent design build projects, owners have begun introducing open-ended, long-term facilities maintenance requirements, for example, mandating a 15 to 25-year design life for certain components. This is problematic because outside of the P3 context, facilities maintenance and operation are owner responsibilities. Contractors should review these obligations carefully to minimize the risk of disputes after project handover. Finally, inappropriate time restrictions. Increasingly, in P3 projects, contracts are including restrictions on the amount of time an area may be available for certain construction activities, without providing a corresponding means to increase those time periods. This creates the risk of a hair-triggered default that cannot be remedied by the contractor. Next slide, please. So the next category we'll discuss is protections of persons and property. And we'll start off by talking about utility risk. Utilities can pose significant cost and schedule risks on construction projects. Encountering unexpected utilities often leaves contractors at the mercy of utility companies who don't typically care about the contractor's schedule obligations. Contractors should avoid accepting utility identification and relocation risk at all times if possible, but especially on brownfield sites, congested sites, or where there is a lack of clear background utility data. Utility risk can be addressed in a few different ways. Number one, by limiting the contractor's responsibility for utilities to the information disclosed in the background information. Number two, by ensuring the contractor is entitled to cost and schedule relief if undisclosed or mislocated utilities are encountered. Or three, by obtaining additional information to supplement owner-supplied utility data. Next topic is contamination risk. Unexpected contamination can also pose significant cost and schedule risk to contractors. Contractors should be wary of accepting responsibility for contamination that is inferable from background reports, or that could be inferable from reasonable investigation. This is especially dangerous in situations where geotechnical reports lack sufficient detail about the presence or levels of contamination, if the project site or surrounding areas are not greenfield sites, or if there are elevated levels of pre-existing contamination or a risk of neighboring contamination, such as sites that are currently or have previously been used for industrial purposes. Solutions to mitigate contamination risk include, number one, obtaining more detailed environmental reports, or ensuring that the contractor is entitled to rely upon the reports provided. Number two, limiting existing contamination responsibility to quantities and types actually identified in the existing environmental data. Or three, using cash allowances in the contract to account for unknown contamination risk. With that, I will pass it off to Jessica.
Thanks, Nick. So moving on to cash allowances, as Bruce and Nick have both mentioned already, cash allowances can form a key part of the contractor's risk allocation strategy when pursuing work. However, that risk allocation can be disrupted if the contract fails to appropriately specify the circumstances in which the contractor is entitled to access a cash allowance, or it imposes a disproportionately onerous requirements before it can do so. This is very straightforward, but cash allowances must clearly be listed within the contract documents to avoid disputes, and being able to recover any sort of change in contract price. So an example of a clause that we've seen recently is that's problematic is, so as Except as expressly stated otherwise in the contract documents, none of the work identified in the drawings and specifications is the subject of cash allowances. So should the contractor in this case fail to notice that the work discussed with the owner as cash allowance is not expressly listed as such in the drawings and specifications, they could be at risk of unrecoverable expenses. So similarly, it's important that the contract expressly states whether the contractor is entitled to relief if costs exceed the value of the cash allowance for a given item. Failure to do so can lead to further dispute with the owner and potentially erode the contractor's fee. It's important to ensure the contract addresses adjustment to overhead and profit or fee due to the expenses in excess of the cash allowance or unexpended cash allowance values. So the contract may or may not allow for the value of work performed under a cash allowance to be included in progress payments. Payment may follow upon completion of the cash allowance work in its entirety, and the cash flow and effects to downstream contractors and suppliers should be considered. Next slide, please. So on payment terms, whereas net 30-day payment cycles used to be commonplace, payment terms are increasing towards a net 60-day or greater cycle. This can impose a significant financial burden on contractors, especially when owners refuse to provide adequate payment security. So improved payment terms and clear owner commitments to pay, which would include guarantees from balance sheet entities, are necessary to ensure that contractors can effectively manage credit risks. So on the note of positive cash flow, terms should be set for products delivered to site but not yet installed. In some cases, the contract will allow for materials to be stored at an approved offsite facility to be claimed within the progress period for which it's delivered. However, there are typically requirements for the offsite facility to be bonded, and there may be specific insurance and documentation requirements to satisfy the terms for that deposit payment. Another way to mitigate risk is to establish a lien holdback trust account. This ensures that there is a balance check which matches the holdback deduction for each progress claim. So any discrepancies should be reported in writing right away to be remedied prior to any credit concerns. While these concerns have largely been addressed in jurisdictions with prompt payment legislation, it remains an important consideration in jurisdictions without legislation. Further, for contractors operating in jurisdictions with prompt payment legislation, it is important to ensure that the contractual payment terms comply with the regulations. Next slide, please. So on the note of prompt payment legislation, it has been established in Ontario, Saskatchewan, just to name a few jurisdictions. It's also established at a federal level. So as mentioned before, the contract terms cannot alter the provisions of legislation, but it is our responsibility as contractors to ensure that the requirements are understood. So citing the general process from the Construction Act in Ontario, some critical elements to ensuring payment certainty, even with prompt payment legislation, is to establish a date of the proper invoice. The owner then has 28 days to pay from the date of the proper invoice. The GC has 7 days to pay after the owner pays. And the GC, it's important to remember, the GC is required to notify regarding non-payment. Next slide, please. So there are additional holdbacks. So this is a growing trend that we're seeing. So owners are seeking additional holdbacks that are in addition to the traditional builder's lien holdback. Some examples are listed here. So a warranty security holdback, to throw a number out there, so that's typically seen, around 2%. An operations manual holdback. This is often for mechanical and electrical trades, as they're the ones with the most onerous requirements for submission. So typically that is set anywhere from 1% to 5% of the subtrades contract. So that's a significant enough value on top of the builder's lien holdback deduction, and any of these other ones. So if we're stacking holdbacks, obviously there's an impact to that cash flow that needs to be addressed. There's also there could be a deficiency holdback that is set at 1% to 3% of the contract, could be more. So it's important for contractors to consider how additional holdbacks impact the contractor as well as downstream subcontractors and suppliers as far as cash flow on projects, and the associated payment timelines and evidence and documentation required for payment release of these holdbacks. It's also important for contractors to ensure they're aware of any right to claim for progressive holdback release, though this may be in relation to Builders Lien Act. Next slide, please. So on the topic of design, build, and P3 projects, there are specific risks noted with payment here. So the concept of minor deficiencies is well established in the industry. As a project reaches substantial performance, the owner and contractor create a list of minor deficiencies. These must be rectified, but the parties agree that they do not prevent the project from achieving substantial performance. So in P3 projects, once substantial performance is achieved, the project moves into the operations phase. During operations, certain deficiencies result in service payment deductions for the month in which the deficiency existed. Generally, this is not an issue, but at times owners attempt to apply service payment deductions to deficiencies that should not attract them. To avoid this, it is essential that P3 contracts specifically define the types of deficiencies that attract deductions and those that the contractor is entitled to complete without penalty. This severity of operational unavailability failures and payment deductions significantly impacts post-construction warranty regimes and costs. The severity arises in two manners, often occurring simultaneously. So the threshold for assessing an unavailability occurrence for deduction is lower with higher standards of performance, lower rectification times, and less time for proper inspection and temporary repairs. And the penalties being assessed are often excessive, sometimes up to $500,000 for a single occurrence. While the imposition of an availability and deduction regime is conventional on P3 projects, the increasing severity of the risk transfer and penalties is eroding the ability of facilities and maintenance providers and operators to function in the P3 space, and it is resulting in significant long-term operational exposure being pushed to contractors. So the last few comments on payment are in relation to substantial and total completion criteria. It's important to ensure that the definitions of and the criteria to achieve substantial or total completion are reasonable and achievable. So this is especially true if there are liquidated damages, payment adjustments, or holdback releases tied to these milestones under the contract. Criteria that are unduly onerous or in the owner's sole discretion should be avoided. If possible, the criteria should mirror those in the standard form of the CCDC documents. So a common inclusion for requesting substantial completion that we've seen is for the contractor to provide a statement that all claims and demands for extra work or otherwise under or in connection to the contract have been presented to the consultant, and that the contractor expressly releases the owner from all claims and demands except those made in writing prior to that date and still unsettled. So this sort of clause would relieve the owner of any risk to further changes following substantial completion or such other milestone date that's noted in the contract. So final payment may be dependent on a final completion clause or multiple clauses, which can be different than substantial performance and owner takeover requirements. Again, it's really important to understand each of the milestones set out within the contract and their impact to progressive as well as a final payment. So that concludes our presentation. So we'll hand it back to Jorgen.
Thank you, everyone. Great work and great information, and talking about everything from the very basics of the contract, from definitions to agreements, fit for purpose, owner discretion, standard of care, performance specification. A lot of good topics there. And so right now, I would like to open up the floor for questions. I do have one to start off with here. So the first question, and this is for all the panelists here, and let's see if we can get Bruce there as well. Perfect. Thanks, Bruce. So the first question is, we were talking about different types of risks in this documentation and in this presentation itself, but what are the most common risks construction companies face today? What are you seeing out there in the industry that could be of interest for everyone tuning in? So I'll just pick one. So I'll pick Bruce there. See if he has some wisdom to share.
I think the answer to that question may be somewhat market dependent, but obviously lately the biggest risk we're all facing is the geopolitical situation in the world and tariffs. And I like to say we don't want to talk about tariffs because everyone talks about tariffs, but it's the unknown and it's the impact of the supply chain in terms of have we got fixed prices or not? Lots of things we can control, labor and other aspects, but that is a wild card right now. I would say for me, from a contracting perspective, the biggest risk is not reading your contracts and not reading what you're bidding. And I think there's a lot of good information in this webinar that maybe you can, take a little bit of time to read the contracts before you bid things so that at least you know what you're getting into, because a lot of trades are not doing that. So I think not reading what's in the documentation in front of you is a big risk.
Excellent. Anyone else who would like to join there? Jessica?
Yeah, thanks, Jürgen. So over here in BC, we do not have prompt payment legislation. So as Bruce mentioned, it is regional. Our major risk is not being paid on time. So the extended payment cycles that we're seeing, the minimal consequence for owners not to pay on time, that's been causing us grief out this way. Another one that is impacting us quite heavily is the utility risk that Nick had gone through. Because of the redevelopment within larger cities, there are quite a few unknown risks underground. So those are the ones that we face quite a bit.
Very good. Thank you for sharing there. Corey?
Yeah, I think the other thing, and Bruce talked a little bit about this, is doing your homework, making sure you know who you're going to be going into business with, whether you're a general contractor and you're working with a client that you maybe haven't worked for before, or conversely working with a subtrade or a subtrade working with a general. Make sure you know who you're getting in business with, because we've seen a lot of cases in the last few years where there's insolvency or you get owners that don't have proper financing in place, and that delays the project. So I think it just comes back to do your homework and know who you're going to work with.
Excellent. Thanks, Corey. And the next question, I'm going to address it to Nick. So this is about going through contracts and agreements. How can project teams proactively allocate risk in their contracts? Well, what's your best practice there?
Thanks, Ruby. So I think, to reiterate what Bruce said earlier too, there's no substitute for reading the contract, knowing the contract. Don't try to outsource it entirely to your legal counsel. Like, if you're the one who's going to be executing as a project team member, make sure you know what it says. So I think that's the first thing. And in terms of best practices for negotiating with clients, I think one thing that's helpful is to try to go back to fundamental principles about who is the best party placed, who's in the best position as amongst the parties to manage a specific risk. You kind of ground the discussion with owners at times too. So.
Excellent. And I'm sure you've been flipping through a few pages of those contracts for sure. Okay, so heading down to the next one. So this is more talking about experiences. Can you share examples where early risk identification changed the project outcome? So I believe, Bruce, you had, I know from our previous discussions, where early risk identification changed how the project was done and lessons learned and things like that. I know you have a couple of stories to tell.
Well, I'll tell one that's off the beaten path here is that we worked with a client for 11 months on pre-construction, and towards the end of the 11-month period, we identified the biggest risk was the client themselves, and we terminated the contract and didn't do the contract. And subsequently, 3 different contractors went through the contract, through the project, which got done eventually with a lot of issues. So from a risk management perspective, our decision not to continue the relationship at that point was fruitful, because we didn't end up suffering through 3 years of grief. It was 11 difficult months, but at least it ended there with minimal financial risk. So that's not exactly the answer to your question, but at the end of the day, it was assessing the risk of the fit of the client we were working with before we got into a much deeper relationship that committed us to multiple years of, as Jessica pointed out, not getting paid on time and a bunch of other things. I think from our perspective, we always do our due diligence before we enter into agreements, and always leave ourselves a door before the actual construction project's about to start to exit if it doesn't feel like a good fit.
Thank you. Thank you, Bruce.
A valid risk management strategy is to just choose not to bid on a job with a bad risk profile. So to Bruce's point, before you get into a bad situation, just could be the best job you never got.
Exactly. No, great answers. And if we look into sort of the product delivery and the innovation piece, looking at different models, from your experience, and maybe I'll ask Jessica about this one, working with different delivery methods like IPD, design build, progressive design build, how would you say different delivery methods influence the risk management strategy? Like, what is how do you see the different models either helping you or when it comes to mastering risk management in construction projects?
Yeah, I'd say, as we all know, each delivery method has its correct placement. So it all starts with educated owners as well. So in order for a contract delivery method to be, delivered adequately, contracts to be balanced, the owner needs to have an understanding of where the pitfalls could be. If they're allocating risk to the contractor, how is that impacting their price that they're receiving? How is it in relation to the schedule? What are contractors having to now account for that could be creating some sort of distrust. So when it comes to delivery methods, I would say the biggest piece is owner education, and part of that typically has fallen on industry. So practitioners such as everyone on this call to help and inform and guide those decisions. Bruce, did you have anything to add?
No, not to that. I'm good. Thanks, Jessica.
Very good. Okay, so that's interesting how the approach is a little bit different in those scenarios. So one question that just came up is about quantitative risk assessment. And this is about the tools. So we'll see. So what are the most commonly used tools for quantitative risk assessment that contractors can utilize, i.e. at risk by Lumivero or Provision for contract assessments? Everyone wants to jump on that one?
I can start it off. So tools for quantitative risk assessment, there are quite a few. You've listed a couple there. I mean, I'm not familiar with these, so I can't speak to their effectiveness, one or over the other. a lot that we're seeing is trending towards early like BIM integration. So modeling, clash detection, quantity takeoffs, based on like 5D modeling. So it all of that plays into being able to simulate different scenarios, as well as account for some of those risks early on. Logistics planning, in 3D or 4D can also help. So looking at any, we'll call it mistake that you can make or identify, prior to groundbreaking, whatever method that is the best way of reducing, costs, because those mistakes don't cost anything. Yeah, as far as most commonly used, I don't know that I can identify that right now, but if anyone on this call does have effective tools, then for sure, by all means, please share them.
So I don't have a specific tool to recommend, but part of the question had to do with contract review software, I believe, and just one. I think it's definitely got potential uses, but just my perspective is that it's not a substitute for actually reading the document, and especially if you're relying upon anything that's powered by generative AI to provide a summary of a particular clause, like can hallucinate, then you need to still lay eyes on the document yourself in order to fully understand what you're getting yourself into. But still can be useful tools to sort of make that process more efficient.
Yeah, and I'll add to what Nick said is that, learning to read a contract, and if you take a look at the document that was the genesis for this webinar, which is the CCA issued risk management document, it goes section by section. And if you learn to read the key sections and look for key elements of the contract, it'll serve you well, because it doesn't take that long to isolate the problematic clauses in the contract and decide potentially quantitatively how they're going to affect your bid or how it's going to affect your ability to execute. So as Nick said, there's no substitute for doing it yourself and not relying on, technology is a great tool to support, but the fundamental is understand how to read a contract properly.
Excellent. Thank you. Interesting answers. And moving on to the next question. So this is an interesting question. Maybe a question we should all ask ourselves maybe a little bit more often, but this may depend on size of project, but how many contract can one person effectively manage?
Jörgen, what's the context of the question in terms
This
of
is
when you say
the
how many contracts can one project manager handle, one contracts manager? What are you referring to?
So I think that's kind of the limitation of what I have here, but maybe I can get the person to add more. But it's I'm thinking from a let's because we talked about project management. Here we go. We got the answer right away. Contract managers at one time. So this may depend on size of project, but how many contract managers can one person effectively how many contracts can this contracts manager effectively manage?
Nick, I might throw that one to you, given the size of PCL and the way you guys work.
I unfortunately don't think I can contribute much because I don't not directly involved in the management of the projects until they start to go wrong. So I think it's
Well, okay, so I'll use an analogy like how many goals can one hockey player score? Some can score 50 and some can score 10. It depends on the person and their capacity to do things, right? I think like the more balls you're juggling, the more likely you're going to make a mistake. But I don't know that we have a specific answer to that, because we might have someone who's a high performer and could handle a lot, and someone who's not so much. So I don't exactly know how to answer that one in a clear
Well,
way anyway.
I can add to it. The person asking the question is definitely right here. So it does depend on the size of the project, the complexity, the experience of the person involved. It also depends on the additional supports that are in place, right? Are there other managers that are able to, support should their involvement be needed for any items that are escalated? And then on the other end of it, do they have any sort of junior person supporting some of the administration that could be delegated on a day-to-day basis. When it comes to, contracts manager, it's hard to throw a number because I don't want to be held to it, but, anywhere from 1 to, 3, mid-sized projects. Again, it's really about that team, collaboration. If you're having issues, completely, we'll tie it back to this topic, risk management. If you have a contract that's completely unbalanced and you are having disputes at every single turn, your RFIs are racking up to the, hundreds, maybe approaching thousands. You've got, change directives that are underway. You've got, delay claims that are active. That's going to take a dedicated person plus a couple more likely to shore up and submit the documentation required to keep the train moving, right? The project needs to keep going. So it is a difficult one. Hopefully there's something in there that could help.
Well, that's interesting. And I was worried that Bruce was going to say, addition to how many goals you can score depends on which team you play for. But that was not mentioned, thankfully. Okay, we'll look at the next question. This is about so I don't know how let's see the application for the contract itself, but it's about working on risk evaluation and using risk evaluation tools in the process before taking on a job. So the question reads as follows: if you can rate as per your own judgment, how likely you would consider Monte Carlo simulation for risk evaluation, and I assume if there's some other suggestion for calculating risks would be welcome as well.
So on this note, for context, sorry, it says MC simulation during both pursuit and execution and time and cost. So in this case, any sort of computation requires data. Again, I'm not really familiar with automated processes for assigning the likelihood of a risk. I guess it's a little bit old school in the method that we use for risk assessment and mitigation. Predicting the likelihood of it is, based on judgment that's specific to, the municipality and the other authorities that you're working with, the others involved in the project. So I'm sorry, I don't have an answer to that one. Have to leave that one open-ended and maybe circle back in another format.
Jorgen, I don't know if I could try to answer this in context with if you were going to get to your list of questions that you sent us about leadership and culture. And, the question you were probably going to ask is how can leaders build a culture that supports proactive risk management? Like Jessica, and I'm way older than her, I'm still a little old school when it comes to risk management. We don't use modeling techniques like that or quantitative techniques. What we tend to use is, experience as an organization to manage risk. And, I'll jump in to answer your leadership question as an answer to this question to this person. And that, how do you create a culture in your organization that supports risk management? And I think senior managers have to be accessible, and they have to be people that share, and they tell stories, and they talk often about their experiences in the industry, because as you listen to stories of experiences, you'll start putting a database together of areas where risk can occur. And that takes you to the organizational part where you hear the stories, you start making lists of various areas of risk and understanding that people have probably experienced many of the things that could be risks on a project. Like, there are very few unique problems in this world in construction, I believe. Like, somebody has misstepped somewhere in the world, somewhere in Canada, in a lot of the puddles we end up stepping in as risk, right? So sharing and being available. I always find senior managers are guilty of spending too much time in meetings and not being accessible to their staff to be able to share, and then playing through scenarios and what if scenarios. And that's a great way to do it internally when you're constantly, what if this happens? What if that happens? And before you get into things, think about plan A and plan B even plan C, right? And you will build a risk strategy around structure and organization and lists and experience. And, you know, it's a combination of all that. And that may be a soft, mushy answer to a question that was very specific about technology and numbers. But that's really the way the industry does it, is we share, we work together, we collaborate, and we make sure we don't have experiences that people go through when we can avoid by telling them about it and preventing them. So that's sort of my roundabout way of answering your leadership culture question, along with answering that one.
No, thanks, Bruce. And it's to your point as well. It's you know, sometimes you have to be going through a situation, and after that, you will be the first one telling everybody else about that risk. So sharing and collaborating is definitely key. I want to switch it up a little bit, because we have a little bit of left time here for a few more questions. So something about, we talked about what we have, what in the past, and what we do right now. But how about we look to the future? So right now there's, you know, technology. For instance, how will technology like BIM, predictive analytics, change risk management, what would that look like in the next 5 years? And I know from a CCA standpoint, that's been a lot of focus on BIM and case studies and things like that. So would like to ask Jessica about this one, because I know we've been collaborating on BIM and things like that. But how do you think the next 5 years, what is it going to look like?
Well, the goal is to increase adoption. There are definitely benefits for contractors to be using it, even if it's not a requirement set out by the owner. Hopefully it'll get to the point where adoption is great enough that owners also see the benefit and will be, you know, ready and willing to accept that as a contract cost, rather than it being something that the contractors have to carry the burden of. Over the next 5 years, you know, one of the attendees here had brought up specific risk assessment technologies, and hopefully those will become commonplace. BIM is used in various methods for different purposes, to try and de-risk a project as much as possible. There's only so much that you can do in advance of actually, you know, finding what your subsurface conditions are, what utilities may exist, you know, permitting or code changes. All of those will continue to add risk. But hopefully we can get to the point where adoption is great enough, and that likely will be led by contractors, to really get to a place where risk analysis is a proactive approach rather than a reactive one.
Right. No, that's interesting. And yeah, we can see from you know, I think it's a matter of getting that understanding how useful the tools are and actually how available they are, but the adoption rate is of course the tricky part that we can see. So I appreciate that, Jessica.
Another comment I can lend to that is there are certain elements of responsibility through our contracts that we still need to be aware of. So in the cases where we are using BIM, we still need to, as contractors, remember that there are avenues for identifying, you know, issues and for them to be corrected with the proper design authority. So just not to lose sight of, again, step one is read your contract, and make sure the project team that's implementing and delivering the project is the one that's up to date, understands it to a T, and they'll be able to carry out the work with as little risk as possible.
Very good. Thank you. Just looking at a question, I think Nick responded to it earlier. It's about AI for contractual risk assessment. Is it possible to use AI for contractual risk assessment? Maybe Nick, you want to elaborate the message on that one again?
Sure. Yeah, I think it's definitely possible. There are lots of tools available. some of which are even marketed specifically to the construction industry. So I think it's an exciting space to keep an eye on, but use it cautiously, be my recommendation. And not as a substitute for reviewing the contract, not to sound like a broken record, but
Yeah, no, absolutely. And we from CCA, we were looking into this as well, and it's also industry to industry, where you have construction is very, very different from buying pencils and things like that. And sometimes these systems are very generic, but at the same time, interesting to get sort of a risk assessment, like a overview as well. So it's lots of good tools, but like a lawyer said here, just read your contract. Okay, so I'm gonna switch over to a little bit about working together and working as teams and so forth. When it comes to working with the contract and working with trades and things like that, sometimes there's comments about we're not seeing everything in the contract as trades, et cetera, et cetera. Is there anything that, I think, Bruce, you have a lot of experience working with trade contractors. Like in your case, where do you, when it comes to the prime contract and trade contractors, what do you think is key in messaging and collaboration?
Okay, when you say in messaging related to that, I mean, obviously you're in a situation, prime contracts in redacted form should be shared. And we go to the extent of pointing out to trades the key elements of the prime contract. And we also go to the extent of ensuring the subcontract is perfectly aligned or as well aligned as possible with the prime contract. So there's no mysteries in the prime contract that don't show up in, say, going from CCDC 5B to CCA 1. It's consistent so that I can safely say to a trade, if you see it in CCA 1, it is in the CCDC 5B and it's consistent. So they're not trying to get away with something or impose conditions upon them. So, I mean, we got to live on both sides of the fence here. We have to get into our sub-trades situation and understand from their perspective. And I think as long as you listen and you find ways to find balance, and the CCA always focuses in their documents on balance between both sides, and owners are very focused on tipping the balance badly in their favor a lot of the times. And we got to find that balance and make sure there's consistency. So, I think that's what's very important is don't try to hide things, make them clear and transparent.
Interesting. And so I have, let's just looking at the time. I have one more question, and then I have a final questions for all the panelists to share. So we've been talking about a lot of different areas around construction. One part is the regulation. So, when it comes to the future and regulation changes, looking at the future and regulatory documentation, do we see potential changes happening in the future? I know out west with prompt payment, that's something that's been working hard on getting implemented. But from a legal standpoint, I know there's different concepts and different construction methodologies that requires new type of legal documentation. But how do we see that? And I'll see, Nick, you seem to be ready there for that question.
We'll see. But so I think you touched on one really important one, which is prompt payment, which is in place in a number of jurisdictions and federally, as Jessica talked about, but it's being considered in a number of others. For example, in BC, they're talking about tabling legislation. I think recently something got tabled in Manitoba. I'm not sure exactly where that's at, but it's coming from in a lot of places. Another sort of trend is we're seeing an increase in enforcement for OH&S offenses across Canada as well. At the same time as we're seeing arguably a lowering of the standard for criminal conviction for certain types of safety offenses as well. So it's there's a lot more. I'm spending a lot more of my time focusing on OH&S these days, and I think that's something that's bound to continue in the future as well. But, yeah.
Thanks, Nick. Anyone else seeing any trends in the legal world or anything that's different from a document or contract management standpoint?
Well, I'll just echo Nick's comment about OH&S because we are seeing an increased focus in Ontario on that from the Ministry of Labor. And I think for everybody out there, until you experience a charge under the Act in your province and have to go through the process of defending one of your employees or your employees going through a process, it's quite eye-opening, and it can be scary for them to understand that they've just been charged and they could very well end up in court and in theory end up in jail. It's pretty serious stuff. So I think it's incumbent on all of us to understand that process and make sure that we're, the people responsible understand their responsibilities. So, but it is definitely something that's more prevalent these days.
Thanks, Bruce. Okay, so we're getting to the end of the webinar. I just want to allow for sufficient time, with the authors of the article itself. So the one question I would like to ask of all of you that's on the panel list and on the call here, what's the one key takeaway from the article that all construction professionals should apply right now from the documentation itself? That's the final words of wisdom.
All right. Well, I'll jump in first, and I think everyone's echoed read your contract. But at the end of the day, I mean, this is a skill that I don't think you can lean on technology to do for you. Understanding what you're reading, understanding what you're signing, understanding what you're committing to. That's a skill that everybody should develop. And as an engineer, I try to explain to my staff that legal, and Nick might appreciate this, but legal work is just like engineering. You build a building, you build a contract. I like to think contracts are filters. You build a good contract, throw your problem in the filter, and if it comes out the bottom the way you want it to, you've got a good contract and you've got good clauses. It's no different than building a good foundation. So kind of attack it as an engineering project if you're in the building business, and put time into the contract, because time spent at the beginning will save you a lot of time during and after.
Yep,
Thanks,
I agree.
Bruce.
I think an ounce of prevention beats a pound of cure, or something I say all the time, because it's the effort you invest on the front end to make sure your terms are clear, both parties understand the allocation of risk, could save you a lot of time and effort and money at the back end of the job, and avoid disputes which don't really serve anybody.
Thanks, Nick.
The key takeaway would be to ensure that contract milestones and timeframes are understood. The reason for that is you don't want to miss your window of opportunity to make a claim for something that you are entitled to by contract. The other one is to, such as we, speak about collaboration, and reasonability. Hopefully that is, baked into the contract, as well as baked into the relationships that you have across the project team. But if not, your fallback will always be what's written in the contract, or, issued as in writing, as part of the contract documents. So those will always be, your guiding, principles, and what you have to enforce whatever situation you're going through. So beyond the contract itself, there are contract documents that are appended. So to understand not only contract form, but everything else attached to it as well, and to the best of your ability.
Thank you, Jessica. And also want to take the opportunity when we have Corey here as well. Lots of experience, lots of wisdom as well. Corey, anything that you can say from your lens, running business and recommendations?
I probably the only thing that we didn't really talk about is, the contracts can be really complex at times, and, making sure that you got the right language that protects you and prepares you for whatever those situations are. A lot of that comes with experience. So, when you're a little more junior, you're really going to have to lean on someone that's got more experience to understand those terms and the tech and the different processes are there. And there's lots of legal firms in the country that are very knowledgeable in terms of contracts. CCDC is some of the best written contracts out there. So, you know, if you don't understand what the contract means, ask someone that can support you and make sure that you understand the terms that are there. Because once you sign the contract, you can't change the terms. So you need to have a good understanding of what you're getting yourself into.
So, Jorgen, if I could add to that, and a story from this morning, as I met with a contractor and an owner this morning, the CCDC2 contract that we were working on with the contractor and the owner, and I walked them through in 20 minutes the key elements of the contract and the key pieces of the supplemental conditions that they should be aware of, so that when they did sit down to read the agreement, they knew where those things were and they understood. Because I said, here's 60 some odd pages of contract, which looks very complex and very, you know, might be even intimidating. But after I walked through, they both said, this was very helpful. I can go away and read it now, knowing where certain pieces are that I can focus on. And I think if you're doing contract negotiations, it's always helpful to sit with the other party and walk through your intent and point out the key areas so that you're not hiding them. And you can say, there they are. And I thought it was a really useful exercise with them this morning, and they both appreciated it. And it will help us get the document over the goal line quicker. So just a story from this morning that played into what Corey just said.
Excellent, excellent, and that's what you all do here as well. You know, you're sharing with the industry best practice, and it's very appreciated. So we're getting to the end of the webinar. So, you know, I want to say a big thank you to our presenters for their valuable insight, for helping bring the discussion to life with real world context. And I also want to thank all the participants for joining us today. We will also make sure that the recording is available. It will be shared on the CCA website and also on LinkedIn. And we hope you gained a clear understanding of risk management. And if you have any further questions or would like to explore this topic in more detail, please reach out to us at the Canadian Construction Association. We're here to help, and we enjoy doing that. So thank you again to everybody, and enjoy the rest of your day.